Greetings, everyone. Welcome to our exclusive Global Leading Voices webinar campaign. We are delighted to have you join us here today. Please be informed that if you have any questions during the presentation, you may type them into the question box in your control panel. The presenter will answer your questions at the end of the presentation accordingly. Now, without further ado, we will turn the time over to our presenter, who will begin shortly.
Hello, everybody. I hope you can hear me well. Welcome to the PECB webinar, GDPR versus US regulation, the differences and commonalities with ISO 27701. My name is Toks Oyegunle, and I will be presenting this today with my colleague, Samuel Plantin.
Hi, everyone.
I wanted to start with an agenda just to take us through what we will be talking about over this hour, and to also frame in your minds the content. So we'll start with an introduction to both of us. We'll go on and talk about a brief introduction to the standard. What exactly is 27701? How does it work? What do we use it for? We'll probably put that within the context of a privacy management maturity map. Excuse me. And then we'll talk about the benefits of implementing a PIMS, a privacy information management system. We'll talk a little bit about the structure, just so you see what exactly you get with the standard, how exactly you can use the different components within the standard. And then at that point, I'll probably hand it over to Samuel, who would then talk about the GDPR, US regulations, probably start with a few basics, then do a high-level GDPR provisions, and then go a little bit deeper into the GDPR, US laws, ISO 27701, the similarities and the differences. And then at the end, we will probably take any questions that you may have. Okay. A quick introduction for starters. My name is Toks Oyegunle. I'm a privacy and cybersecurity management specialist. Probably been doing this about 27 years now, industry experience. This spans information technology, project management, privacy, cybersecurity. These days, I work more as a principal consultant. I work as a coach to professionals, and I also do a lot of non-executive director type stuff. Specifically to 27701, however, I've helped many companies use that to achieve GDPR compliance, CCPA compliance, help companies through audits, and also done quite a bit of training around that. I have multiple certifications across privacy, security. My background, however, is in tech. So I studied computing, studied business systems analysis, and I'm a Harvard Business School alumnus. I'll hand over to Samuel to do a quick intro.
Yes, thank you, Toks. So I'm Samuel Plantier. I'm a privacy counsel at Outbrain, a digital advertising company, and I have less experience than Toks, but hopefully enough for this webinar. I'm a data protection expert and an intellectual property and information technology lawyer with 6 years of experience. I started as I practiced as a lawyer for 2 years, and when I moved to London, I moved to consultancy for quite a few years as well, and now I'm in-house privacy counsel. I focus especially on consumer and competition law issues in the digital market, AI, data ethics, the articulation of blockchain technology with data protection requirements, and of course, digital advertising. This is what I'm doing now at tech, e-privacy, etc. I have a PhD in law in the digital economy and consumer law. I hold several certifications in privacy as well, the CIPP Europe, the CIPM, and I'm a fellow in privacy.
Thank you, Samuel. So maybe now let's do a quick intro into 27701 itself. At the end of this, we should at least understand what it is, how it works, what we use it for. And what is it? Well, it's a relatively new ISO standard. I think it came out around 2019 when the ISO organization realized the need to probably enhance the existing 27001 that people are more familiar with to include requirements for a privacy type system. Can you still hear me? Okay.
Yes, absolutely. Sorry.
Good. So it gives us a specification for a privacy information management system as an extension to the information security management system, the ISMS, that we would typically have with the 27001. Obviously, it's a globally recognized international standard, which comes with the credibility and kudos, with having an ISO certification or standard for your organization. But like I said earlier, it's based in information security. So it's an extension to the 27001 requirements for an ISMS. Now, I do get a question a lot of the time, and I'll quickly answer that here, where people say, oh, if it's an extension, does it mean you have to have 27001 before you can have 27701? And yes, that is the case. However, it does not mean that if you don't have 27001 before, you can simply do both together at the same time. But it does sit on top of 27001. As a standard, it's regulation agnostic. And what do I mean by that? I mean, it's applicable broadly to multiple regulations. So you can use this as part of your compliance efforts, whatever the privacy regulation you are complying with. So it may be the GDPR in the EU, it may be the UK GDPR, or the DPA in the UK, or the CCPA in the States, or even in Brazil. You can use 27701 as a key part of your privacy information management system. Okay. It can be independently audited, which means, just like we can do with 27001, we can get a certification body, come in and do an audit, and we get our audit certificate, which says, yes, our privacy operations are now fit for purpose. But having said that, some people simply use the standard as a benchmark. So they align with it and don't necessarily get audited against it. Okay. One thing I thought I'd close on here is clients are now increasingly asking for ISO certification as a way to confirm people's privacy efforts. So prior to this, what we could do was just send a questionnaire or maybe come in and do an internal audit. But now people are saying, well, do you have 27701? It's starting, and I think we will see more of that with time. Okay. But I thought we could situate 27701 within the context of a privacy management maturity map or a journey. So if you look at this graphic and you look at the left side, you see a lot of red, a lot of distrust, which is where companies do not have any privacy resources, any people, systems in place. And you see you go through 2, 3, and 4 when you start to spend minimal time on privacy issues. So privacy is more of an afterthought than a mainstay of the organization. And different companies tend to fit in one box or the other. Sometimes they might straddle two. Okay. But by the time you get to 3, you're starting to have some sort of a structured approach to privacy. You may be following some sort of framework, but you're not really compliant with any particular regulation yet, at least not fully. When you start to get to 4, you have a framework, you also have a regulation. So you may have a privacy framework, you may have the GDPR, for instance, you may have the CCPA, which you are now using to build a robust type of compliance program. However, it's regulation based, and at the level 4, it's still internals, which means it's all driven by what your DPO or CPO does internally and your privacy team. However, when you get to 5, now you've actually got a standards-based privacy information management system. This is when you've implemented 27701. Okay. What do I mean by externally compliant? It means now, if you've implemented 27701 and you've now been audited and certified against that, then you have documentation which can now prove your assurance to any third party. It may be a supplier, it may be a competitor. Anybody can now see that, oh, whoa, these guys are on top of privacy. Okay. And I thought if we looked at it that way and you saw that 27701 comes in at the way end, right, you'd see why and how it's such a big deal, really, in terms of privacy. Okay. What are the benefits? I thought we'd talk briefly about a few benefits of this, and clearly it's got a risk-based approach, so you identify your risks. We look at the control objectives, the controls themselves that we use to mitigate those risks. But it also creates, increased structure for data protection activities. Like every other standard, it's very prescriptive as to what we need to do. it's very demonstrative as to how we need to do it. The good old showers, I guess, the 27,001 boards on the call, I'm sure would relate to, where it specifies the organization shall do this, which means it's an obligation, not some advice. Okay, it supports compliance with the GDPR, but in addition to that, all other privacy regulations. Okay, and it facilitates a culture of continuous improvement. Okay, it makes sure we have personal data management as part of our culture, either via ongoing training, awareness campaigns and sessions and things like that. And the final point is what we referred to earlier. It provides increased independent assurance. So once you've gone through an audit, you've got your certification sorted out, it's almost as if, you know, you've got something that can go on the website, which gives everybody that assurance that, no, this organization definitely have taken privacy seriously. Okay. Okay. Let me go on. So here, I wanted to just talk about the scope, the structure, actually, starting with the scope. But as many of you may know, 1 through 4 here is actually standard for most ISO standards that we have. Okay. So I'll probably start at number 5 and try and explain. So as we know with 27,001, we have the requirements for an information security management system. Okay. The 27,001 being the precursor, obviously, to 27,701. But then we have 27,002, which provides the guidance. So 27,001, think of it as telling you what exactly is expected from you. 27,002 telling you, you know, this is probably a good idea, consider this, consider that. Prior to this, there were 2 separate standards, 27,001, 27,002. With 27,701, they've both been merged. So with the one standard now, we actually get the requirements for the PIMS, for the Privacy Information Management System, and also the guidance for the PIMS. Okay. When you go to 7 and 8, you now look to see, and this is where it speaks more about 27,002 and more specific guidance, but now it takes into account the context of your role from a data protection standpoint. So are you a PII controller? Are you a PII processor? And then it looks at it through different prisms. So if you're a controller, you'd look to number 7. If you're a processor, you'd look to 8. And if you do both, like many organizations do, then you would need to look at both, but within the context of your role at the time. Okay. At the end of the standard, we have, I think, about 6 different annexes, okay, which is quite helpful. So you have the Annex A and Annex B. Once again, this looks at the controller or processor perspective. But here you have the actual controls, the control objective, the controls themselves, what you need to do to mitigate the particular privacy risk. But also, when you get to Annex C, you also get a mapping to ISO 29100, which is the privacy framework standard. So you get that mapping in there as well. So you see how the privacy framework standard maps into 27,701. Okay. Annex D, I think, is important and relevant to a lot of people because this is where it maps to the GDPR. Now, as we're seeing, many new regulations are an offshoot in a way, or at least a variant, let's say, of the GDPR. But what Annex D does is it actually takes the GDPR and all the relevant clauses and then maps it to 27,701. So you see what you need to do within the standard to comply with the specific clause. And I think that's very helpful to most people. I mean, you look at Article 30, you look at it, it tells you exactly what you need to do to actually comply with Article 30. Annex E, here we look at like PII processors providing cloud services, 27018, and also a bit of guidance in there as well for PII controllers, 29151. Okay. The most important one, however, I wouldn't even say most important, but where you would actually start, and it's funny they put this at the end, but this is where you would typically start, with an implementation gig on 27701 is where it tells you how to apply 27701 to 27001 and 27002. So it just gives you like a breakdown, a little mini framework in there that says, well, you want to do this, change this. This is how you bring it up to speed or up to date in general. Okay, so that's a very quick overview of the standard, and we started this way to give you some context of what 27701 is in isolation. What we would now do is, and I'll hand it over to Samuel, who would now take us, now that we understand what we're talking about with the standard, he would now take it to the GDPR and other US law. Okay, here you go, Samuel.
Thank you very much, Toks. It was very informative. So I'm going more to discuss on the legal side of things and to map the differences and the similarities and differences with ISO 27701 and how we can help support your compliance journey. But first, let's go back to a few basics. I hope that by now the audience is probably very aware of the GDPR, but just as a reminder, the GDPR is a law effective since May 2018 in the EU on data protection, and it's regulating the processing of personal data of individuals located in the EU and the UK after Brexit. The GDPR has been transposed into UK law for now, and regardless of the location of the data controller. Another important piece of law to know generally when you process personal data globally is the CCPA, the California Consumer Privacy Act, which is effective since January 2020 and is aimed at enhancing privacy rights and consumer protection for residents in California. And it will be supplemented by the Consumer Privacy Rights Act, CPRA, from July 2023, where most of the changes are going to reinforce the rights and to make it closer to GDPR. We also have in the US a few more laws that have been recently adopted. We have the Virginia Consumer Data Protection Act effective in January 2023. We have the Colorado Privacy Act, which has been adopted very recently and is going to be effective in July 2023. We had a few initiatives which didn't go through so far, in particular in Florida, in the state of Washington, the one in Washington DC. There are a few areas where some bills were really well advanced and were not adopted at the end. As an interesting initiative I've picked up for this webinar in particular is that there is a bill in Ohio on privacy, which would require data controllers to have an IST compliant privacy program, which is a fairly interesting one, different than ISO 27701, of course, but a fairly interesting initiative where you have to, controllers actually have to implement a framework, a proper privacy framework. Next slide, please. So in terms of certifications and codes of conduct in general. So although the GDPR provides for codes of conduct and certifications, there is actually at this date no general tool that has been approved so far. There are a few sector-specific initiatives, one in cloud services, one in cloud infrastructure service providers, or also for data protection officers. You can certify as a data protection officer in France in particular. But there is no general tool, no seal of approval, which says you are compliant with GDPR, as in a certification or code of conduct so far that has been adopted. It may happen in the next few years, but so far there is no such certification which has been approved. There is also the NIST privacy framework I was talking about earlier. So what is the difference with the ISO 27701? So the first one is the NIST privacy framework is issued by NIST, which is a US institution, and it's more a privacy framework. It's a voluntary tool to help organizations to identify, assess, and mitigate privacy risks for their privacy program. So it's not a certification, it's a tool to help you to identify and to assess the risks. So it's a different tool that you may use as an organization. And finally, you have ISO 27701, which Toks talked very extensively about. So I'm not going to add on to that, but it's an extension of ISO 27001 standard to cover personal data processing. And it's not just a GDPR certification, it's a separate tool. Next slide, please. So what are you going to find in GDPR and how you can map that against ISO 27701? So the GDPR is going to cover the material and territorial scope, is going to give a lot of definitions and principles that you need to have a lawful purpose. You need to identify the correct legal basis for your processing. It's going to tell you, it's going to define consent, what is constitute valid consent. It's going to have a few provisions on children's data and what are special categories of data, sensitive information that you need to protect more than regular personal data, and also to have some special reasons, special grounds to process. Then after, you're going to have all the data subjects' rights, so information, access, rectification, erasure, restriction, data portability, the right to object, and also the right to object to automated decision making, and to ask for an explanation on the logic involved in AI and algorithms, which is a very interesting one. You're going to have provisions regulating the different roles of parties, controller, joint controllership, processors, their respective obligations as parties. Next slide, please. You're going to have the obligations such as you need to maintain, to capture and to maintain your records of processing activities, to implement security measures, although the GDPR is fairly high level on security measures. It gives some guidance like pseudonymization, anonymization, encryption, but it's not as granular as ISO 27701 is going to be on this matter. So the ISO 27701 is actually a really useful tool for that, because the GDPR is pretty high level. It's fairly normal coming from a law, because if you input too detailed, too granular security measures into a law, it's probably going to be obsolete in a few years. So it's pretty normal that the GDPR stayed fairly high level on this matter. You have everything that's going to be around personal data breach notification to data protection authorities and data subjects. You're going to have obligations around privacy by design and by default, DPIAs, data protection impact assessments, which are a tool of privacy by design. The situations where you have to mandatory situations where you have to appoint a DPO. The rules around international data transfers, which is also a huge bulk of compliance at the moment when you want to transfer data outside of Europe with the Schrems case. And then you have all the regulatory provisions around enforcement, the European Data Protection Board, the one-stop shop, etc. So what can we say about GDPR, US laws, and ISO 27701? In terms of similarities, interestingly, the GDPR and ISO 27701 overlap in many areas. Many of the controls, most of the controls you are going to need under ISO 27701 are actually enter into the accountability requirements you're going to have under GDPR. And so it's a very useful, ISO 27701 is a very useful tool to map what you need to do against GDPR and vice versa. So as Toks mentioned, there is the Annex D, which is mapping the different articles of GDPR with ISO 27701. So it's a very useful tool on that. And it's going to be mostly the same with all US laws, really. Because you are going to have with the CCPA, the CPRA, the Virginia Consumer Data Protection Act, and Colorado Privacy Act, many obligations under these laws, which are generally a bit less strict than GDPR, are going a bit less far than GDPR. Many obligations under these laws are going to be captured by the controls of ISO 27701. So this certification is absolutely useful to map your requirements and to help with your requirements. However, there are also some differences. And as a data controller or data processor, you need to be aware of these differences, because the first thing is that ISO 27701 takes a definition of personally identifiable information, which is very different than the one of the GDPR. You're going to have much more stricter. Personally identifiable information generally going to cover what is considered direct identifiers under GDPR, and not personal data overall. Personal data under the GDPR is much broader. It's going to be indirect, is going to be indirectly identifiable data, some referrers, some identifiers, cookies, for instance, as well, are going to be captured into this definition. So the GDPR is much more broader in terms of the obligations you need to have, whereas if you only focus on the definition of ISO 27701, you're going to only focus on the data that is generally considered personal data, such as names, date of birth, address, etc. The GDPR is much more broader. The second thing to know is that ISO 27701 is a list of controls. Ticking the box, ticking a control or meeting a requirement doesn't mean that you are compliant with GDPR. So for a very good example for that is under ISO 27701, you're going to see, do I have a retention policy in place? Yes. So you are meeting the requirements under 27701. However, it doesn't mean that your retention period is adapted or proportionate. And it means that you could still be fine under GDPR because you are keeping the data for too long, for instance. Having a data retention period of 10 years might not be compliant in some countries where you should more expect it to delete the data after 5 years. So that's one example where you need to have a broader view. You need to take into account broader requirements than just having a control. It's not yet, sorry. Another example is if you identify that you have a legal basis, it doesn't, under ISO 27701, it doesn't mean that this legal basis is lawful against GDPR. So ISO 27701 is going to help you to have a list of controls to demonstrate your accountability as a data controller and having a standard to audit against, but it's not going to help, is not going to necessarily mean that you are going to be compliant. The last thing to know, the last difference is that many of the US laws we discussed previously, the CCPA, the Virginia Act, the Colorado Act, they are only triggered in certain situations. So generally it's going to be only in the private sector, only for consumers, so a very restricted area, only for companies who earn a certain turnover, certain amount of annual turnover, or where you have some threshold or volume of data processed. So for instance, 100,000 individuals, and then you have to comply. Is not as broad as the GDPR, which encompasses all type of data subjects, employees, customers, citizens, and other areas. So this is where complying with ISO 27701 is going to help, because you might want to have in place a privacy framework, a privacy program, and a certification and an audit standard to audit against, where you might not actually trigger the requirement to comply with the law in some areas in the US. So there are also some differences in this aspect between US laws and ISO 27701. Notably, as I was mentioning, most of the laws in the US are only applicable to consumers. The CPRA will be applicable to employees later in 2023, but it's pretty uncertain still, because there are a lot of pushback from companies in the US. So most of the time, it's only going to be applicable to consumers. And I think that's all for us. Please, if you have any questions, don't hesitate to ask. It was a real pleasure to be presenting with Toks in this webinar, and ask your questions.
Thank you, Toks and Samuel, for delivering this very informative webinar. PCB offers training and certification courses, which will show your dedication in implementing and managing privacy-related frameworks. And most importantly, you will get recognized worldwide. Now, before moving on with the Q&A session, I am happy to inform that the newest PCB training course, Ethical Hacking, is coming soon. This course will help you in safeguarding the networks and systems of businesses and governmental agencies, amongst others. For more information regarding the Ethical Hacking training course, please check the link on the chat box. Okay, now we'll go ahead and take some time to answer some questions from the attendees. The first question is, does a company have to maintain two management systems, ISMS and PIMS, or are they integrated?
Toks, you want to take this one?
Yeah, definitely, I'll take that. No, you can actually integrate the PIMS into the ISMS. In fact, that's the better way to do it. What you find is there are a lot of requirements in the PIMS that relies on what you've already done in your ISMS anyway. So you can actually add it onto it. I hope that helps.
Thank you, Toks. The next question is, considering the increased number of specifically US laws and regulations, what do you consider as the best strategy for compliance?
It's the $1 million question. It's true, as a privacy professional myself, it's true that complying with US laws is becoming harder and harder, especially if we end in a few years with 50 different laws. I would say two things. One of the first thing is, although it's pretty a bit in pause at the moment, but we can still hope to see a federal privacy law. Many experts were tabling on it for 2021. I think it doesn't look like it's going to be in 2021, but still, it's only the beginning of the presidency of Joe Biden. It can still happen. The other thing is that generally the laws in the US, which have been adopted so far, the Colorado Act, the Virginia Act, and the CCPA, are not excessively different from one another, and you can reasonably comply with one and be relatively assured that you're going to comply with the others. But generally, as a strategy for compliance, if you don't want to look at everything, one thing to know is that generally complying with GDPR is going to, because it's a very strict requirement, complying with GDPR means that if you have to comply with US laws, you're always going to probably end with lesser requirements in the US. So complying with GDPR will be already a very good start. There are a few nuances you will always have to look at, especially the do not sell my personal information button in California, which is very specific, and you will always have to, you won't be able to have a one-size-fits-all approach. But complying with GDPR is probably one of the best approach you can have if you don't want to have a look at every specific law in the US.
Okay, thank you, Samuel. The next question is, how do you distinguish between GDPR and US regulations? What is the main difference? And would complying with GDPR take care of all US regulations at this moment?
Okay, so it's a bit the same. I was a bit covering that, but I would say one of the main differences between GDPR and US regulations in general is what I was covering in my presentation. The US regulations in general are going to cover only consumers, and with a thresholds of revenue or volume of data subjects. So, whereas the GDPR is a general data protection law. It means that it's going to cover all data processing you are doing as an organization, irrespective of revenue, of localization, etc. So that's the main difference. You won't necessarily have to comply with a US law compared to GDPR. The other thing to noticeable, I would say, is that most of the time when it comes to marketing, to sell of information, etc., in the US is going to rely on opt-outs. Whereas in Europe, under GDPR, is most of the time going to be based on consent, opt-in. So that's most of the time, that's one of the main hurdle you might encounter especially if you are a commercial company, a commercial organization, and you are doing direct marketing, digital advertising, etc. One of the main differences is going to be that in Europe you have to rely on consent, and in the US it's on an opt-out basis. The other, in terms of compliance, general global compliance, that's a bit the issue at the moment. You don't really have one-size-fits-all approach. Complying with the GDPR in the first instance is going to give you a reasonable assurance and robustness in your privacy program, so that you know that in the US you will only have to make very small adjustments. You will probably still have to make some, especially under in California again, where you have very detailed requirements, very detailed and granular requirements in terms of the information notices you need to provide to consumers on do not sell my personal information, etc., which have to be labeled exactly in a precise way to be compliant, which you cannot capture under your GDPR obligations solely.
Okay, thank you, Samuel. The next question is, to what extent does ISO 27701 overlap with NIST?
Do you want to take this one, Toks, or do you?
I'm not familiar. NIST, I think, is something they use a lot more in the States. So I don't have an extensive overview of NIST, actually. So I'm not sure I understand where the overlaps are. Are you on top of that, Samuel?
No, I mean, I know broadly NIST. I would say there are very different tools. The NIST privacy framework is more guidance on how you need to implement a privacy program and how you need to assess the risks, etc. There are not a list of controls that you're going to have under the under ISO 27701, for instance. It's not going to be like you need to have data retention policy, for instance. It's more going to be, are you taking into account that and that, are you taking into account the risks to data subjects of your processing into your privacy program, the sensitivity on the information you have, whether you are processing payment information or etc. It's more a tool to a balancing tool to assess the risks and mitigations in your privacy program. It's more an implementation tool rather than an auditing tool, to be more precise. It's still in the domain of privacy, so obviously you'll be able to audit NIST outcomes with ISO 27701 auditing tools, of course. But the NIST is really prior is going to be the start of your privacy program, and then you are going to audit if you have implemented the correct controls with ISO 27701. So there are different tools at different stages, I would say.
Okay, thank you. The next question, how does certification help with data transfer issues to the US, especially with the new EDBP requirements to update SCCs?
Right. So it's an interesting question. There is no certification of code of conduct adopted under GDPR at the moment, which allows an organization, a data controller, to transfer data outside of the EU to the US or somewhere else, for this matter. I remember I have seen somewhere that there was a code of conduct that was being drafted and discussed, so it might happen very soon. But for now, there is no tool, although it's actually anticipated and mentioned by Article 49 of GDPR. You don't have any certification of code of conduct at the moment, which allows a company to adhere to the code of conduct, and that would say, I'm fine with transferring data to the US or somewhere else. So that's the first thing. The other thing is that under the new guidance of the DPP and the new standard contractual clauses, where the country of destination where you transfer your data, you must implement supplementary measures if there is a risk of mass surveillance in this country, which includes in the US in this case, as we all know after the Schrems case. So these measures, they can be pseudonymization, encryption. It can be it can be not sending some data into the US at all. It can be implementing the right contractual provisions to challenge all the requests you may have from, I don't know, intelligence services or whatever. Having an ISO 27701 certification may help in terms of demonstrating that you have implemented sufficiently robust security measures, etc., but is not going to be all of your demonstration to transfer data outside of the EU. So it's going to, again, it's a useful tool. Certification, the ISO 27701 is a certification, is a useful tool to demonstrate your compliance, but it's not the only one. It's not sufficient in itself.
Thank you, Samuel. The next question is, what will be the impact of US federal privacy laws on the state laws?
It's a good question. I don't know. It depends on how the federal privacy law is going to be adopted. It might probably, if there is a privacy law adopted, it will be probably with the objective of replacing all the patchwork we're having between the different states. So it will likely supplement and supersede state laws, but it's really a guess in here. I'm not sure.
Okay, thank you. What tends to be the greater consequence of a slow take-up for GDPR and privacy framework? Is it financial penalties or loss of customer confidence?
Well, the biggest risk obviously is the enforcement and fines. That's for sure. I mean, we all know that it's 4% of your global turnover, and I would say that data protection authorities in Europe are not particularly laxist on it. Although they are not distributing fines to every breaching company, but we've seen very huge fines to British Airways, to Amazon, to Google, several 100 million euros fine from time to time. So the financial consequences are real, but more than that, I would say that the risk of reputation and beyond customers, the risk on your reputation as a damage to your brand is really, really important. Whether you are working B2C, and it means that you're going to struggle. You will have to notify data subjects if you have a data breach. You're going to have a loss of revenue because you are losing consumers' confidence, and then it means that you're going to have less people buying your products or services. But also, if you are in B2B, it can be also very damaging to your reputation, because it means that probably your customer base is going to look for an alternative. And so I would say more than the fines, the damage to a brand can be fairly important. And it's probably not to take lightly, especially in 2018, 2019, it was acceptable. In 2021, it's becoming less and less acceptable that you are not compliant with GDPR, or there is compliance. There is being in breach of GDPR completely, and there is also not having implemented all relevant, or being in a gray area. It depends on it also depends on the breach. But if you have a data breach because of very poor security practices, for instance, this is with the situation typically where your brand is going to suffer the most damage.
Okay, thank you. Is ISO 27701 mandatory for the organizations as PII processors?
I can probably take that. No, it's not mandatory. It's something you can choose to do or not. It's not mandatory at all.
Okay, the next question is there a standardized privacy impact assessment to use whenever we conduct privacy assessments to our organization?
There is no, I wouldn't say there is a standard official tool that you can use. There are a few data protection authorities, especially the CNIL in France, which have issued their own template to use for organizations to help. But after that, there is no official template framework to use, because it's completely left to the appreciation of data controllers and processors to do their PIA. As long as you capture in a DPIA, as long as you capture the risks correctly for data subjects and you mitigate them correctly, there is no standard approach to do DPIA. You have a lot of companies, a lot of consultancy, etc., which provide a very useful templates, very useful methodologies and approaches to do it. Some data protection authorities which have captured the, which have also delivered tools, standard templates to use, but after that, if you want to change them and to more suit your needs, it's absolutely fine.
Thank you. And the last question is, are there any size limits from which the US privacy laws apply?
So there are I'm not sure I understand the question correctly, but there is no higher threshold limits, if that's the question. There are some lower thresholds where as an organization, the different privacy laws are going to be triggered. You need to look at each of them. I don't know these limits on the top of my head, but generally you're going to have a double threshold, which is going to be either one or the other. It's going to be a volume of data subjects. So, for instance, if you process, I'll say 100,000. The data if you process personal data of more than 100,000 California residents, you're going to be subject to the CCPA. Or if you are doing, I don't know, more than $500,000 revenue turnover in California, then you're going to be subject to CCPA. It's not these figures. Please don't take them. As they are. They are just examples, but these are the common thresholds, and they vary between Colorado, Virginia, and California. So you need to check in each of the states, depending on your situation, the revenue and the volume of personal data you process in these states to see whether or not these laws are applicable to your situation.
Okay, thank you, Toks and Samuel, once again for presenting today, and thank you everyone for attending today's webinar. Please be informed that this session is recorded and will be posted on our website and YouTube channel along with the slides of the presentation. Thank you all, and looking forward to having you on our upcoming webinars.
Thank you very much. Thank you, PECB, for the webinar.